be express appointment, or there can be express agency, or there can be implied. We have already discussed about both of these, and remaining two are with us, that is agency created by necessity, or agency which is to be ratified later on by subsequently by the principal. So how much I can recall, we were discussing the implied authority, and I have already given you an overview that implied agency arises from conduct, situation, relationship of the parties. It is to be inferred from these three aspects of the relationship of the parties. Thereafter, another kind of the creation of implied agency is by way of the estoppel. And I hope all of you remember what is rule of estoppel. However, the rule of estoppel which you have studied as in your Indian Evidence Act, right, under section 115, is not strictly applicable in your law of contract, but this is a way by which we can have creation of an agency. So let us just talk about how agency can be created by estoppel. That if somewhere a person allows another, or somewhere a person placed another person voluntarily in a situation, that a person with ordinary prudence, a third person with ordinary prudence will take that person as your agent. For example,
Ma'am, excuse me, you need to be a little slow actually. As you just said it all in one go.
Okay, sorry. I'm so sorry. I was just talking about what is the meaning of an agency created by estoppel, right? And I hope that everybody knows that what is rule of estoppel. Rule of estoppel as such you must have studied in your section 115 of your Indian Evidence Act. And you must have made reference of rule of estoppel in your Indian Contract Act in your last year. Here it was given or discussed by different justices in regard of the application of rule of estoppel on minor. So you must have studied that whether the rule of estoppel is applicable to minor or not in your Julia Prasad case, right? And in another case. So here I want to ask you a question just to make all of you involved in the class. Even if you were not listening to me earlier, answer me one question: whether the rule of estoppel is applicable in case of minor or not. What is your answer? Answer me whether the rule of estoppel is applicable on minor or not. Rule of estoppel is applicable on minor or not. Try to answer me. Any one of you? Then I will connect the estoppel rule to your agency.
No, ma'am.
Not applicable.
Not applicable.
Let me explain you. Rule of estoppel is just a rule of evidence. It is having relevance for evidence. And the rule of evidence cannot overrule substantive law. Always remember that. And what is the substantive law of your Indian Contract Act? Substantive law is minor is ineligible to make a contract. Where minor is declared as ineligible, incompetent, then rule of estoppel cannot give incompetency. Or let us just talk about in a very simple language that what is not allowed to do in law directly, you are not allowed to do it indirectly as well. So if or let me make it more simple, अगर आप एक हाथ से कार नहीं पकड़ सकते तो हाथ घुमा कर भी कार नहीं पकड़ सकते. In other terms, what is prohibited directly in your law, similarly that you are not allowed to do indirectly. If a minor cannot make a contract, he is incompetent, then by making the rule, just the rule of evidence, you cannot make him competent to make a contract. So rule of evidence is never to overrule the substantive law. And this is the basic principle. And a principle which we are going to discuss here, that how an agency can be created by the estoppel. Here please be clear, estoppel does not reveal the same thing, but is there is this to be considered under your 115, because rule of evidence is the same rule is applicable as it was applicable in case of agency, that it is the rule of evidence cannot overrule the substantive, and we are moving with same application of the principle, but I'm explaining you how there can be creation of agency by estoppel and what will be the nature of an agency created by estoppel. Now I'm giving an example. Suppose I voluntarily, means with my own knowledge, with my own willingness, allow you to put yourself in a situation, such situation, towards the rest of the world, towards the third person, that it will appear to any other third person that you are my agent. Actually, please be real. Actually, I have not appointed you as my agent, but I voluntarily created a situation, or I put you in a position that to a third person with ordinary prudence, it will be always an impact that there is agency. Then later on, if there is any contract made by that third person with ordinary prudence and negligence, right, with you on my behalf, right, then even though it will be resulted into a valid contract, and I will be liable similarly as a principal here. But you need to always remember that even though there was no express creation of agency, but there is creation of agency by estoppel. Means if earlier I allowed you voluntarily to act or to behave like my agent, and because of that allowance, because of that voluntary situation created by me, if third person entered into a contract with you, and thereafter I will be liable as a principal, right? And this agency will be treated as agency created by estoppel, and the real nature of the agency will be implied agency, because by circumstances, by my conduct, by my willingness, I gave an impression to the third person who is of ordinary prudence that you are my agent. And once I gave an impression, and when third person believed that impression, and because of that belief, he entered into contract with you, and by supposing that you are my agent, I won't be later on allowed to step back. And this is definitely based upon rule of evidence. Now I just want to demarcate between the rule of evidence application in case of the minor and rule of application of estoppel in case of agency. In agency, there can be application of your section 115 of Indian Evidence Act because nowhere in your Indian Contract Act expressly it is not prohibited that agency cannot be created by implied way. Because where there is a creation of agency by estoppel, it is in nature of implied. And itself your Indian Contract Act is aligned implied agency. So there is no prohibition. When there is no prohibition, the rule of evidence will be, when substantive law is not prohibiting, the rule of evidence will be applicable. But in case of minor, why we never apply the section 115 of the
Madam,
where the application of rule of evidence will be resulted into violation of the substantive law, the creation of an agency by estoppel. Right? There can be creation of an agency by application of rule of estoppel. Let me first of all explain you that what is estoppel. Estoppel, all of you must have studied in your section 115 of Indian Evidence Act that one person made a statement by believing that statement, one person made a statement which is not true, which is false, but by believing that statement, another person did some act. Later on, the person who made the false statement will bound by his word. It will be treated, the false statement which was made by you will be treated as true, and you will be bound by your words, you will be bound by your acts. And I was telling you that what is how there can be creation of agency by estoppel. Let me just give you the same example which I was giving you earlier. Suppose I allowed you voluntarily with my full knowledge to act as my agent, to represent yourself as my agent. I put you in a situation, or I myself voluntarily created such situation that to a third prudent, ordinary prudent person will have impression that you are my agent. However, actually there is no creation of agency by you, between you and me. So if somewhere, even though there is no actual creation of agency in an express way between two people as principal and agent, but the person allow another person to place himself such way or to represent himself such way that he is agent, right? So take the same example. If I allow you to create a situation that you are my agent, right? And later on, because of such creation of situation, it is an impression with the third person who is of an ordinary prudence that you are actually my agent, and he, by believing that situation, he entered into a contract with you by believing that you are my agent. Then in such situation, I won't be allowed to step back. Reason, I was having a full-fledged knowledge that you are placing yourself as my agent, even though I allowed you. So I will be bound by that, and it will be because of estoppel. So there can be creation of an agency by estoppel. It is allowed. And here I was, and another thing I want to tell you, that by and large, what will be the nature of an agency created by an estoppel? It will be implied agency, right? It will be implied agency. And here I was connecting it to you, another aspect of Indian Contract Act, in which regard you have already studied the rule of estoppel in your first year. I just want to recall you that you have studied the rule of estoppel in case of minor in your last year, and you must have learned one thing, that rule of estoppel is not applicable to the minor. And I just want to tell you that why in one area of contract rule of estoppel is applicable, which means that in agency, and why in another area of contract rule of estoppel is not applicable. For that, I just wanted to make you clear that rule of estoppel, there is one basic principle of legal jurisprudence, that the rule of estoppel cannot overrule the substantive law. Right? Rule of estoppel is here to facilitate the evidences, but you can never overrule the substantive law with the help of any rule of evidence. So if substantive law is strictly prohibiting the minor, is strictly declaring that minor is incompetent to make a contract, then by applying the rule of evidence, you cannot give him the power. The power is not there in the substantive law of contract, and by rule of application or by application of rule of evidence, you cannot give him the power. For that, I always give an example that what you cannot do directly, you are not allowed to do indirectly just by application of rule of evidence. Rule of evidence cannot validate something which is not allowed by substantive law. For example, I just told you earlier, अगर आप सीधे हाथ से कार नहीं पकड़ सकते, तो means if it is prohibited in law to touch your ear, तो आप ऐसे हाथ घुमा के ये कह के कि I am touching it, otherwise you cannot allow. तो किसी भी तरह से आप कार नहीं पकड़ सकते. Similarly, why at same time we are, and how at same time we are applying this rule of evidence, that is section 115 of Indian Evidence Act, to agency. Because in substantive law of Indian Contract Act relating to agency, there is a law that agency can be created by implied way. So, estoppel, by application of rule of estoppel, we are not violating the substantive law. So this is the reason it is allowed to create an agency by estoppel as well. I hope estoppel agency is clear to you. Is it? Answer me. Is estoppel agency clear to you? Am I audible? Okay. In chat box I can see. Now I'm telling you another kind of the agency, another way of the agency to which we used to consider also another form of the implied agency. Relationship of a husband and wife. Let me explain you that a wife will always be considered as the agent of her husband. Means suppose your wife is going to purchase something or going to make any contract which is relating to the necessity of household, then she can do that. She can do that and she will be treated as your agent. You will be bound with act of your wife, and it will be which form of the agency? It will be implied form of the agency, right? So it is allowed. So as long as people continue, husband and wife continue to live in the same, live in the houses, wife will normally do the, because wife will normally do the household shopping, husband will pay the bill. The law of principle and agency will always cut equally to law of the husband and wife. So impliedly, a wife will be having authority to bind her husband by her credit purchase, however subject to some important limitation. And what are those limitations? It must be relating to the necessities. It does not mean that wife can use your credit card always for her, to fulfill her hobbies and all. It is
Ma'am?
Yes.
So, ma'am, this would work both ways, right? A husband would be an agent of the wife as well.
No, due to the typical situation of the specifically of Indian society, generally, even still today, generally this is the husband who is running, who is taking responsibility of the household. Even the wife is earning or wife is working. In that situation, what we used to believe in the law, that wife is having right to maintenance, and this is the. However, things are getting changed now, but still we have not achieved that level. Still, this is a duty of the husband to run the household or to fulfill the responsibility of the house relating activities. अगर घर को चलाना है तो ये husband की duty है. तो in case of the husband will not be automatically impliedly treated as an agent of his wife unless and until wife has specifically authorized him. So this is the law at present, right? Husband may also be treated as agent, but only with express authority, and there will be no presumption, just like in case of the wife. Is it clear?
Yes, ma'am. Thank you.
Okay. Thereafter, we are talking about. Let me tell you one thing. Earlier, I was, trying to explain you the things with the case laws agency. Then later on, I have discussed with the seniors, and what I come to know about it on agency, there will be the short notes. So I'm just now focusing with the perspective, just like with the perspective of your LLB exam. However, agency is very important topic for your competitive exam, and you must have a complete knowledge of agency. So what I'm doing, I'm explaining you the Bear Act provisions, and I'm explaining you the other essential, each and every other essential requirement of the agency or possible, aspect of the agency. But I will now take up the specific cases only, because otherwise we won't be able to complete this topic, which is not of so much relevance from perspective of your LLB exam. So thereafter, I want to tell you another kind of the implied agency which may be there. That is agency of necessity, or which is to be covered in a separate head, agency of necessity. So agency of necessity is basically is a aspect that somewhere agent do not have the power to do a particular act, right? But due to some extraordinary situations, he will be impliedly allowed to do that. So it is something that although the power of agents are ordinarily limited to particular acts, yet extraordinary emergencies may arise in which a person who is an agent may form the necessity of the case and be justified in assuming extraordinary powers, and his acts fairly done under such circumstances will be binding upon the principle. And let me tell you from where these aspects originated. It was originated with the marine adventures. Now what happened in past, we were not having good mode of the communication, and if some you appointed someone as your agent to deliver some cargo or something like that, and the ship ship is in the sea, but due to some mishappening, right, the ship is stuck into the sea, and the agent is not able to communicate to the owner, to the principal, or to the owner of that those goods, then in such situation it is allowed to dispose the property, to dispose the goods, to sell it to somebody else, how much it is possible to save the principal from the loss. So it is allowed in certain special extraordinary circumstances if it appears to the agent that there is need to take some extra step or extraordinary step or exercise some power for which he is not otherwise authorized, then he may do so. But always remember, if somewhere it is possible to communicate to the principal before taking such extraordinary step or before exercising such extraordinary power, then he is bound to communicate or he is bound to inform the principal and to take his direction whether this is to be done or not. But if somewhere it is not possible to communicate to the principal and it appears to the agent as an emergency, then he can do so, and nature of such agency will be agency by necessity. And let me tell you one thing. For any agency by necessity, there is not even need to have pre-existing agency. So कोई pre-existing, so I gave you an example in which already agency was going on between the two people, that you are my agent, you take my property to this or that place through the cargo. लेकिन अगर कहीं पे आपके और प्रिंसिपल के बीच में ओरिजिनली कोई एजेंसी नहीं है, you are otherwise in connection to the principal with some other authority, but later on you realize that there is need to take certain special step and you need to act as an agent, then in such situation you may do so if otherwise it is not possible to communicate or to take direction from that particular person. So the way you will act will be considered as agency by necessity. But there are certain guidelines that agency by necessity must always be with good intention, right? It must be bona fide and it must be, it must be actual necessity. It must be that it must be a situation which cannot be avoided otherwise. So this is what agency by necessity. So another agency by necessity example I can give you, that relief of an infant is in need of urgent medical attendance, then any person acting on his behalf may call the service of a doctor or may any doctor volunteer his service. So in that situation also it will be considered as agency by necessity. And one thing which is to be always followed as a principle to check whether the agency by necessity is valid or not. For that I am telling you the test. When we will see that there is a creation of a valid agency by necessity, first, where it is inability to communicate with the principal, when you are unable to communicate the principal. Second, act should be reasonably necessary. Should be reasonably necessity. And the last, which is here, the act, the way you have reacted or the way you have created the agency must be bona fide plus actual agency. So I hope I have justified to explain you the kinds of the agency which can be there, that is a express agency, implied agency, and the various mode of the implied agency in which it can be created, and agency by necessity. And the fourth one, about which I discussed in your earlier classes, that is by subsequent ratification of an unauthorized act. Then let me explain you that by subsequent ratification of an unauthorized act is a separate aspect, means ratification of a past act of an agent, which I will discuss in detail with help of the legal provision from your BEAR Act. Now, with this, I am now today moving towards the relation of principal and the agent. So that what is the relation of the principal and agent, and in that aspect, first of all, I am going to discuss with the duties of the agent. Okay, Manisha Yadav, what should I repeat? Please tell me. What is needed to be repeated? All these are implied agency, agency by ratification, by estoppel and by necessity. Okay, let me tell you, implied agency is what? Implied agency is by estoppel. Means various form of the, which I explained you, implied agency में क्या क्या covered होगा? By estoppel and by and the relationship of husband and wife. In implied agency, what we are going to cover up specifically, estoppel and relationship of husband and wife. And how far the necessity is concerned, however, it is a kind of agency, implied agency, but we are treating it in a separate head. It is extended version of implied agency, but as there is need to have specific condition fulfilled, that inability to communicate with principal, act should be reasonably necessary, so it is to be considered under a separate head. Another difference between the implied agency and your agency of necessity is what? In agency of necessity, the principal is not aware that you are doing something due to extraordinary situation. But in implied agency, whether it is in form of what, whether it is in form of estoppel, the principal is having knowledge that you are representing as an agent. Is that clear? And another thing is what? Okay, from second point onwards, is the point is clear to you, or should I repeat again, or should I move ahead? Answer me. Is it clear now? Okay. Now let us talk about specifically, which is a very important area, relationship of principal and agent. And today we will talk about duties of agent. First of all, let us talk about duties of agent. Then we will talk about rights of agent. Okay, let me just specify the basic funda of rights and duties. I hope everybody knows and are aware about it based upon your fundamental rights, fundamental duties, and your every legal jurisprudence is what? What is your right? That is my duty. Which is my duty? That is your right. So right now we are talking about duties of agent. So in other way, I am saying rights of principal. Is it clear? So we are talking about, first of all, duties of agent or liability of an agent towards the principal. So what are those duties? So let me discuss one thing before taking up the duties. That, do you remember your section 1? Okay, just 1 minute. Do you remember your section 184? Section 184. Anybody tell me what is section 184? You do have direct with you, you are having internet with you. What is section 184, which we did earlier?
Ma'am, it says who may be an agent.
Okay.
Any person can be appointed as an agent.
And there I told you, even a minor can be appointed as an agent. You remember? I told you, no?
Yes, ma'am.
Now please focus back to your section 184 and read the second phrase. Read the provision again. I would suggest you, as between the principal and the third person, any person may become an agent But no person who is not of age of majority and sound mind can become an agent so as to responsible to his principle according to the provisions in that behalf herein contained. Responsible. Responsible here means duties. So one thing I want to tell you, what we are going to study as or to learn as in regard of duties of agent will not applicable in case the agent is minor. Okay, the agent is minor. So if somewhere you have appointed any minor as your agent, he will not be bound with any duty which we are going to study towards the principle. Right? So the very first duty, okay, let us talk about duties of agent. Mutual rights and duties of principal and agent may be wholly provided in their contract. So first thing you must have learned in your first year that law of contract is a unique substantive law. And can you explain me why I'm making this statement? Do you agree with this statement? Law of contract is the unique nature of substantive law. Okay, let me first of all tell you what is the nature of law of contract, whether it is substantive law or whether it is procedural law. Answer me.
Ma'am, it's substantive.
Substantive. Then why it is unique nature? Answer me.
Ma'am, because the parties themselves create the rights and duties.
Yes. This is unique because you have done your Indian Penal Code, you have done your family law, you have done your TPA, you have done your number of laws, and there you must have learned one thing, that already what is to be done, what is not to be done is decided by the particular law. So it means when you are talking about Indian Penal Code, already it is written there that what is murder, what is not murder, and you are strictly bound with that, you are strictly liable according to that. But your contract is giving, law of contract is giving you liberty. Giving you liberty, law of contract is, going to draw a circle for you. And within that circle, within that legally allowed, circle, you can create your own terms and conditions. You can lay down your own rights and duties in regard of one particular substantive contract, right? And the point which is amazing here, the terms and conditions laid down by the parties will be enforceable by the court, right? Through the court. So if I said that I want to purchase your house, you said that I will pay the 10 lakh rupees for this. So this is the situation, this is what term and condition laid down by the parties, by the ordinary person like you and me. But even though that term and condition will be enforceable through the court as any other right laid down by the court in any other substantive law with the power of sovereign. Right? So this is what it is unique. So first thing which is to be learned, that when we are studying about the rights and duties, principal and agent are totally free to lay down any right and duty, but definitely that right and duty must not be violating the law of contract. Otherwise, the circle which has been drawn by the contract, within that limit you can lay down any right and duty as per agent or as per principle. So, but the following, the duties which we are going to discuss right now, those duties are general in nature. What does it mean when I am saying general in nature? Means whether you are incorporating it into your contract as a term and condition or not, irrespective of the fact, it will always be there. Right? By application of your law of contract, by application of your provisions of contract, it will be considered as what general duties. So, The following duties of general are of general in nature and are imposed by law upon every agent unless they are, and moreover, you can modify these general duties by excluding with a special contract, but definitely you can modify only where it is itself allowed by the contract. Okay, here I again want to recall something which you have already done. At number of times, in number of provisions, you must have studied in your Indian Contract Act in your last year that unless contrary is agreed between the party. So this is the principle, this is the law. Unless contrary, something agreed between the party. So time to time you can see in your Indian Contract Act provision that Indian Contract Act is so much flexible that it is giving even power to make the changes in the provision if something you can agree, otherwise contrary between the party it will be allowed, otherwise general principle, general practices is. So let us talk about first duty to execute mandate. Before that there is Anushri, about the minor, I will explain in the last of the class. So today, first of all, I am going back to the duty. So duty to execute the mandate. First and foremost duty of every agent is to carry out the mandate of his principal. So this is not only based upon your Indian Contract Act. This has not been specifically, incorporated. This duty which I am discussing with you is not incorporated in any specific provision of your Indian Contract Act, but this is based upon law of equity. So even this duty is not allowed to be supported by your Indian Contract Act expressly. It is there, it is based upon law of equity that every agent is bound to execute the mandate of his principal, right? So I hope first is clear to you. Duty to execute the mandate. Now, let us talk about the second one, duty to follow instruction or the customs. So for that, please take out your section 211 in your PAR Act. Section 211. Section 211. Have you opened your PAR Act? Message me if once you are ready, because we need to read the provision. Ready? Okay. So read agent's duty in conducting principal business. An agent is bound to conduct the business of his principal according to the directions given by the principal, or in absence of any such directions, according to the custom which prevails in doing business of same kind at place where the agent conducts such business when agent acts otherwise. If any loss be sustained, he must make it good to the principal. If any profit occurs, he must account for it. Right? So this is the provision. Okay, before explaining you the provision, I want to discuss with you I want to discuss with you the illustration given to your section. So read the illustration as well. An agent engaged in carrying on for B a business in which it is the custom to invest from time to time at interest the monies which may be in hand. Omits to make such investment, A must make good to B the interest usually obtained by such investment. Read the second illustration from your PAR Act as well. Be a broker in whose business it is not the custom to sell on credit, sells the goods of A on credit to C, whose credit at the time was very high. C, before payment becomes insolvent, B must make good the loss to A. So let me just tell you one thing. Section 211 is declaring one basic duty for the agent, that agent is bound to strictly act according to the directions of the principal, right? So there can be two situations. One, the principal has given you certain direction. Second, the principal has not given you any direction. Because we have already learnt difference between the agent and the servant. And as I told you, in case of agent, we used to tell the agent that you need to do this act, but we are not bound to direct him that you do in this way. But in case of servant, we will always direct him that how it is to be done. But section 211 is making you clear that if somewhere in a contract of agency, principal has given some particular direction to an agent for running a particular business, then the agent is bound to act only as according to the directions. But if somewhere no directions has been given, no direction has been laid down by the principal, then agent may do it his own, but as per the custom required, or which usually or generally used to be followed by any other ordinary person while conducting similar nature of the business. And if he deviated himself from the prevailing custom, he did something new, he did something else, right? Then it will be at his own risk, and if due to that different practice, if there is any loss, then the agent will be bound to fulfill that loss to the, or to make good that loss to the principal. And we have already, which second point, Hari Arora? You may turn on your mic also, or otherwise please write your
Duties of agent.
Duties of agent. So your section 211.
Yes, ma'am.
Okay. Just a minute. I just told you that for a particular business, suppose I am running a particular kind of the business and I appointed you as my agent, and this agency creation is for what purpose? To run my business by you on my behalf. Then section 211 is making it clear that if, first of all, as a principal, I am free to direct you or to lay down certain directions for you for running the business, my business, by you on my behalf. You are running my business on my behalf as my agent. So principal is free to lay down the directions that how it is to be run. But if somewhere the principal has given you the discretion or the freedom that how to run the business, then in absence of direction, as an agent, what we are expecting you as an agent, that you will follow the ordinary prevalent customs which are here prevailing to running the similar kind of the business. Suppose I am dealing with the traveling business, that what other travelers, what other people doing the similar kind of the business, what kind of the practice they are following, what kind of the custom they are following. So it is expected by law, you will follow similar kind of the custom for this similar business which you are running on my behalf. If somewhere then you are having freedom or liberty to run the business, and rather than following the prevailing custom for that particular business, prevailing in that society, prevailing in that economy, you deviated yourself from that custom and you did something as your own, with your own discretion. You did something new, you take a risk, you followed some different practice which was not to be followed by the other businessmen doing or dealing with same kind of the business. So if due to that new practice, due to that new step, if there is any loss, then the agent is bound to make that loss good to the principal. He is bound to pay the damages. He is bound to make it good to the principal. There will be his liability. Is this clear? This is a duty of the agent. Is the point is clear? Make it good means suppose if you would have, answer me, the Basant Kumar, if you have followed the prevailing practice which is prevailing in that particular economy relating to that particular business, if you have followed that, then the profit could have been 10,000. But you followed, you laid down your own new practice, you deviated from the prevailed custom, and because of that there is profit this time 5,000. So मेरे को loss कितने का आ रहा है as a principal 5,000. So for that loss of 5,000, the agent is bound to pay to the principal. मतलब आप देखोगे कि अगर ordinary customary practice so we must have been getting 10,000, but you have followed something different and we are getting 5,000. So in actual, the principal is in loss of 5,000. So this will be the duty of the agent to pay 5,000 from his own side to the principal. This is the meaning of make it good to his principal. Make the loss good to his principal. Is this clear to you?
Ma'am, I have a question.
Yes, please.
So, ma'am, if the agent breaks a custom and acts in a way which is not the general custom and makes a profit, so that profit would be the profit of the principal only, right?
Yes, he will be bound. He will be entitled. This is making you bound as an agent, either to act strictly according to the direction laid down by the principal or follow the general custom or the practice.
No, ma'am, I'm saying if he makes a profit by breaking the custom,
then he will be account for it. He will be entitled to get the profit. It is
like the principal
level. Yes. No. Not
so, ma'am, it says here that when the agent acts otherwise, if any loss be sustained, he must make good for it to his principal, and if any profit occurs,
yes,
he must account for it. So wouldn't that mean that he should account it to the principal and give it to the principal?
So I'm telling you the same thing, na?
Oh, okay.
This is what make you force that you act strictly according to the direction, or if somewhere directions are not there, to the prevailing practice or the custom. So that because agent is someone who is acting under the authority of the principal, and he should not act like a principal. So this is what making you realize that you are an agent.
Yes, ma'am.
Right? So I hope I am able to make you the first duty clear to you. The second, actually first I have already told you, which is not based upon your Indian contract, which is based upon your law of equity. Now let me tell you, where suppose somewhere the principal laid down the directions, but directions are ambiguous in nature. Right? Then also the agent may act himself. Right? And moreover, along with this duty, when the principal has given you any direction, then you are bound to maintain the secrets of the business as well, to maintain the confidence, secrecy, and non-disclosure of any sensitive information to someone. So this is also duty covered under your सेक्शन 211 कि आपका course of conduct, course of business relating to that particular business is what you are not supposed to disclose the secret of one particular business to another person. So this is also to be covered. So an agent is also under duty to maintain confidence, to maintain secrecy, and for non-disclosure of any sensitive information